Okay, so this is LAWS 13017 Civil Procedure, Week 3, looking at instituting proceedings, service and notice of intention to defend, and in particular problems 6 through to 8. All right, I'll just stop sharing that for the minute. So we've got 3 problems to see. There's a bit in these problems in terms of drafting of documents. So we will get stuck into them. So the first one is Matsuka Engineering. Okay, so just with that name, what issue does that give rise to? Matsuka Engineering, whose registered offices at 3 Queen Street, Brisbane. Because there's an issue just with that little phrase. Does anybody know what it is?
Whether it's a company or a business name?
That's right, because that has implications on how you do your pleadings, and it has implications for who gets served with various things as well. So that's something you'd have to clarify with the client. Anyway, they've instructed you to institute proceedings in the Supreme Court of Queensland seeking recovery of $900,000 in liquidated damages for breach of contract made on the 30th of March last year. Okay, there's 2 issues there. And just in that sentence, what considerations or issues arise in that statement? Any ideas? What things should you...
breach occurred?
Well, yeah, okay. Well, okay, let me rephrase it. Whether a breach occurred, yes, but I'd say that all of the elements of the cause of action present. What about the amount of 900,000? What does that indicate to you?
Supreme Court jurisdiction.
Jurisdiction. You've got to get used to these, looking at these sorts of problems in a very methodical way. Okay. Names of the parties. What sort of an entity are they? That affects what you're going to do. The amount of money involved, which triggers the whole issue of jurisdiction. Okay. Where are they located? We were told that they are in Queen Street, Brisbane. So that also is relevant to jurisdiction potentially. Then you're told it's liquidated damages. What does that mean? Liquidated damages.
Well, it's a claim for in some way not performing the terms of the contract that entitles the plaintiff to make a claim.
That's true, but what's the difference between liquidated and
calculated?
Yep, go on, Vivian.
So liquidated damages have been calculated, while unliquidated has while the unliquidated have to be assessed by the court.
That's right. So liquidated damages are a sum certain, so you know exactly what the amount is. Whereas unliquidated damages, you really ultimately it has to be assessed by the court, but you will have to give estimates of it in relation to the pleadings. So this is liquidated, which is good because it's simpler to deal with. All right, we'll keep going. The purchasers under the contract are listed as dodgy brothers of partnership. Okay, so you're dealing with a partnership. Who do you sue? If you're suing a partnership, do you sue the partners or do you sue the partnership name?
You're suing the partners.
You can sue them in the firm name though, as well. Okay, no, that's fine. Dodgy associates a business name, and then you've got, so we'll look at that issue about business names and who you sue there, and also whether they're registered or unregistered. Then you're told, assume the partners of Dodgy Brothers are Arthur Dodgy, a resident of New Zealand. Okay, so if we have to go after Arthur, we're dealing with someone in New Zealand. There's special rules for Trans-Tasman service in relation to New Zealand. Then Sally Dodgy is a resident of Lord Howe Island. Well, what's that? What's Lord Howe Island? Part of Australia, isn't it?
An Australian administrative.
Yeah, in fact, it was looked after by New South Wales until recently when Queensland took it over in terms of services and things. But anyway, so it's part of Australia. and it's covered by it's a territory in Australia, basically. I mean, I could have put in there, you know, Antarctica or somewhere other. There's lots of those territories, and they're covered by the Service and Execution of Process Act as well. So anyway, we'll keep going. And then you see that Stuart Dodgy is a resident of Queensland. All right, well, that's okay. So just from that one paragraph, all the different sorts of issues that you need to keep in your mind that potentially could be relevant here. So then you're asked the actual question. It says, draft the initiating process using the correct court form, assuming any necessary pleadings. You probably could include there any necessary facts, because we don't have all the facts to be able to fill it in completely, but some of them you'll have to make up. So what is the initiating process for the Supreme Court? What starts the proceeding?
Form 2.
Form 2, which is a what?
Well, it's a claim.
A claim, that's right. So it's a claim in Form 2. All right. The rule that sets that up is Rule 22. A claim must be in the approved form, which is Form 2. And then Rule 22 sets out a little collection of things that you must do in relation to a claim. So you have to state briefly in the claim the nature of the claim made or the relief sought in the proceeding. Okay, so what is the nature of the claim that's being made?
A claim for a breach of contract.
Yes. What sort of a contract?
A written contract?
No, it might be a bit hard for you. It's actually, sorry, what was that?
Purchase, supply and purchase, perhaps?
Yes, it's actually the traditional phrase that is used is goods sold and delivered. So if you go and look up the pleading textbooks, there's a classic one known as Bullen and Leak, which is pretty old, going back probably 100 or so years, but it documents all of these. So this claim would be it's a claim for damages for failure to pay for goods sold and delivered. That's the typical way you would describe this. So you're claiming damages for failure to pay for goods sold and delivered. All right, so then if we go back to Rule 22 again, it says you have to attach a statement of claim. So that's the next document we'll look at in a minute. And see, it says for a claim filed in the district court or magistrate's court, well, it's not that, so we don't have to worry about that. Then the next bit of it, the claim and attachment must be filed and then served on each defendant. So how many defendants do we have here? Who's the first defendant?
Well, I came up with 3, but I'm wrestling in my mind to this other question about suing in the name of the firm. But anyway, I reasoned that because it was a partnership, they were joint and severally liable for this contract.
Exactly.
So I put Stuart, Sally and Arthur in as defendants 1, 2 and 3.
Well, what you'd actually do, there's only actually 2. One is Dodgy Brothers and the other is Dodgy Associates. Because with the partnership, if you sue in the partnership name, remember partnerships can sue and be sued in the partnership name. It captures all of them because they all are liable for each other's.
Yeah, so
you don't have to list them individually. It gets them anyway.
I must have misunderstood the legislation, Stephen, because when I read the legislation, what I thought it was speaking of in terms of partnerships is that if I as a partner in a firm want to sue a fellow partner, it's provided for in the legislation for me to do that against the partner of the firm. But does it also extend to the partnership being sued in and of itself by a third party.
But when you say the legislation, what are you?
Sorry, the rules.
Okay, so if you have a look at Rule 83,
Yeah.
so that's headed proceeding in partnership name. And it says, in part, a proceeding against persons alleged to be partners may be brought against the alleged partnership in the partnership name. So that's Rule 83, Subrule 2. And Subrule 3 says the partnership name used in the partnership proceeding must be the name of the partnership when the cause of action arose. So that tells you actually sue them in the partnership name.
So am I incorrect in saying that I've listed Stuart, Sally, and Arthur as the first, second, and third defendants?
You're not wrong, because that rule's discretionary. It says may be brought against the alleged partnership in the partnership name.
Oh, okay, right.
You're not
So
wrong. It's just it's a less convenient way of doing it.
Right. So then it was correct in the other. What I was relying on was the plaintiff. The plaintiff is relying on joint and several liability. Is that correct?
Yeah. Well,
Yeah.
if you're suing them individually, then they're all going to stand or fall as members of that partnership. But just generally, the convention would be to sue in the name of the partnership, and it captures what you're trying to do anyway. I mean, Rachel's raised the issue there of service. It would be more. It is true. It would be more expensive in service, particularly in our case, given where they are. It would cost you more. But you want to take advantage of the rules that give you a simpler way of proceeding. So anyway, Rule 83 tells you that you can go that way. So I'd do that just as a matter of course with this sort of thing. So okay.
Given that two of your partners, one's in New Zealand and one's in Lord Howe Island, simply serving a partnership would certainly be a lot simpler in this case, wouldn't it? Oh,
absolutely. Absolutely. It's going to cost you a fortune to serve these people. So it's better to do it using the advantage of that rule. So you only have to serve the partnership in its own name. All right, well, let's keep going because we've got a lot to get through with these rules. So, okay, so all right, that's that. So we have the actual claim itself. So let's have a look at that claim. So I'll just put this up and I'll circulate this to you. Okay, so there's what it looks like. Of course, it wouldn't have that black, that grey bolding behind it. So being the Supreme Court of Queensland, registry would be Brisbane. I made up the file number because that would be allocated to you when you actually filed it. When you took all the documents in, they'd stamp it, they'd give you the file number. So you've got the plaintiff, first defendant, second defendant, the claim, damage to the failure for goods sold and to pay for goods sold and delivered. Most of the rest of this is just standard form. This stuff at the bottom, the actual footer. So each page of the claim, if it goes over more than one page, should have this footer on it. So that, which is prescribed by the form itself, which just tells you that who the solicitor representing the plaintiff happens to be. Then you've got things like, it warns them as part of the form. It warns the defendant about any issue of any potential irregularities or lack of jurisdiction, that they could put in a conditional notice of intention to defend, which basically is saying that they're reserving their rights to challenge the jurisdiction if they want to. Now, in our case, that doesn't really arise, but that's a warning, a standard warning that's put in there. Then you've got the particulars of the plaintiff. Now, if you found out it was an actual company, you would put PDY, LTD, or whatever type of company it is. Their address for service, which in this case, because they're represented with the solicitor's address, and then it lists who it's served on, and then it has the footer again. So that's basically your claim. Now, the other thing that had to be attached to the claim was the statement of claim. Okay, so if we have a look at that document, there's a few things to talk about with this one. So it's got the same court heading. And then you've got your actual pleading elements of it. And there's various ways of doing this. So there's no, 100% correct way of doing this. There's variations, but in this case, I've assumed that Matsuda Engineering is actually a company. So if you're going to say that, you'd say at all material times it was incorporated, and I've just put assumption there, is registered as offices at that address, and then you'd put their Australian company number in as well. All right. Now remember, the statement of claim has got to plead the elements of the contract, which is for goods sold and delivered. So you'd say on the 10th of June, I've made up that date, Arthur Dodgy, Sally Dodgy, Stuart Dodgy trading as these things, which is Dodgy Brothers, the partnership, and Dodgy Associates, which is a business name, orally agreed to purchase a widget or something. We don't know what it was. So that's more questions you'd have to ask your client, what was purchased from Matsuda Engineering for $900,000. Okay, so that is essentially an offer to purchase. And these are the elements of the contract. So you're identifying what the sale relates to, when it happened. It's an oral contract because we don't know any wiser at this point. It's an offer, and then you can see the next element would be acceptance. Matsuda Engineering orally agreed to sell. That's your acceptance. The widget to the defendants. Then the delivery bit, the widget was delivered to the defendant's place of business on such and such a day. Okay, so that's goods. We've identified the goods. We've said that they've been sold because you've got an offer and acceptance, and there's been delivery, which are all the elements of goods sold and delivered. And then the terms of trade were net 30 days of delivery. So that just means that they were supposed to be paid within 30 days of delivery. And then the breach is that the defendants have failed and refused to pay the purchase price. Okay, so there's all the elements of the contract. And you then have to set out your claim for relief as part of the statement of claim. So the amount of claim, 900,000. I just made up the interest amount. You can work that out. Filing fees, I'll explain how we get those figures because you need to know how to do that. Solicitor's fees I made up, and then that gives you the total. And then the rest of the form, you'll notice it's got this footer as well. Slightly different to the claim because this is a statement of claim, Form 16, under different rules. So you have to make sure you've got the correct footer in there. And then it tells them that they can put in a defence, a notice of intention to defend. And then it just repeats the actual claims. But it does also tell them that if they don't do anything, they risk default judgment, and there'll be additional costs of that amount. Now, you need to know where all these figures are coming from. So if we go back, because I've settled this out, I can run through them because I'm not sure you would have gone that far in looking at the actual amounts and how they're calculated. But essentially, the actual costs for filing are made up of two components. One is the appeal cost fund. That's a very small amount of money. It's actually $29.90. And that comes because of the Appeal Cost Fund Regulation 2010. So the Appeal Cost Fund is like an insurance fund, which is essentially used when there's an appeal, and ultimately the appeal is successful because the judge made an error of law at first instance. So they're able to actually compensate the initial plaintiff for an error that the trial judge made to the extent of about $15,000. But that's made up of these little bits that are collected every time a claim is filed. So you need to include that amount, and it changes every year, these amounts. So you always have to look them up. The other component of the cost of issuing a claim and a statement of claim is, if it doesn't involve a company, is $1,232.90. That's your filing fee. But it climbs to $2,911.90 if at least one plaintiff is a corporation. So that's why, another reason why you need to know whether Matsuda is a corporation or not, because the filing fee is significantly more if it's a corporation. Don't ask me why that's the case. It just is. That's how they've set it up in the actual regulations. So you need to check those regulations. And then when you do that, you end up with the total filing fee, including this appeal cost fund of $2,911.90. And that was the amount which appeared in the statement of claim as part of the claim.
It's interesting to note, sorry, Stephen, it's interesting to note the court's website actually include that $29.90.
Yeah, they did. Yeah, I know. I was looking at it today because when I go through and update the answer, I was looking at it. When you click on the website, they actually include the amount. But I've broken it down so you see where it actually comes from.
Probably just something to be aware of in practice, though, because if you just remember, oh, the filing fee and add it on, but you use the website rather than the...
Yeah, it does tell you on the website, but I noticed that as well when I was looking at it today. I thought, that's really odd. Wouldn't you think they'd say the filing fee is this and the appeal cost fund amount is this and then the total is that? But they don't do it that way.
It would keep it uniform across the legislation and their website, wouldn't it?
It would, but they don't do it that way. So I don't know why. But I've set it out so it's clear where it's come from. The other sorts of things for the potential costs involved are really set out in the schedule to the Uniform Civil Procedure Rules themselves. There's a scale of costs in Schedule 1, and it says that you can get $46.40 for personal service by a solicitor or employee for each party, which is $92.80, which is not going to go terribly far with some of our parties. And you can have various amounts for solicitors' fees as well. Ultimately, when we get further on into the course, you'll see that all of these things can be, ultimately, if the trial happens and there's a decision made, and costs usually follow the event, then there could be an argument about the total amount of costs. So what will happen is that there will be a bill of costs prepared by the solicitor, or typically they'll farm it out to a firm that specialises in making these bills of costs because they're quite lengthy documents. It's cheaper to get a specialist to do it than doing it yourself. And it'll set out all the items that happened. I wrote a letter to somebody on such and such a date about this, and then there could be an argument whether that should be taxed off or not. Was that letter necessary or not for the litigation? So at the end of that process, after a taxing master looks at all of that, you can end up with about 60% of your costs. But we'll look at all of that way down towards the end of the course. But anyway, for our purposes at this point in time, I've just assumed a lot of these figures so that you can see how they're incorporated into the actual statement of claim down here, these things. Now, we'll talk a lot about interest and things later on in the unit. I'm just trying to keep it fairly simple at this point so you can see what the forms look like and where things are coming from. All right, so far so good. So that's that. Okay, so we come back up to the next part of the question. Go too far with this. Actually, I'll stop sharing that. Find the actual question again. So the second part of the question, how should the parties be described in the originating proceedings? Okay, so how should the parties be described? So if we're looking at the partnership, how are we going to describe the partnership? This was the point we were looking at earlier, Rule 83, proceedings in the partnership name. So what's the partnership name? Dodgy Brothers. And that's what you describe in the originating process. Okay, so in terms of service, you can serve it on any one or more of the partners at the principal place of business, on anyone having control or management of the business at the time of service. When we say business, that's the partnership. Okay, so that's that. Mitsuda, we don't know what they are. So as I said before, you need to work out whether they're a corporation or not. If they're a partnership, then you'll do the same thing that you did in relation to Dodgy Brothers. Then they would sue in the partnership name of Mitsuda Engineering. More likely they'll be a corporation. So you'll need their full corporate name, and watch out when it says pty.ltd. That's different from pty ltd. Don't forget the dots. You've got to get their name exactly right. So it's worthwhile doing a search based on their ACN number, Australian Corporations number, to get their correct name. You don't want to be in a situation where you actually commence proceedings in the wrong name. And it could be simple things like full stops, but that's really important to get that right. Because you can have situations, and there's all sorts of case law on this, where a simple error like that is made, a limitation period has expired, then there's arguments as to whether you can correct the original claim if the limitation period has expired. So be careful when you start your proceedings with these names, both of the plaintiffs and the defendants. It's really important to get that correct. Most things in civil procedure can be corrected, but it costs money to do that. You want to avoid that from happening. But if it involves limitation period expiries, it's some things you just can't correct. And that's one of the areas which is problematic. So spend some time and get the names right. That's why I've set this problem just to drill that into you, because it's really important. All right. What about if Dodgy Associates, if it's a registered business name, how do we know whether it's a registered business name or not?
Use the ASIC search.
Well, yeah, there's actually a business names register you can look up as well. So you can actually easily determine it that way. And you can actually start the proceedings against them in their registered business name. So that's fine. What about if they're an unregistered business name? So they're not registered. What do you do then? There's a rule on it. There's a rule for everything. So if you have a look at Rule 113, service in relation to a business, it says, this rule applies if a proceeding is brought against a person in relation to a business carried on by the person under a name other than the person's name, which is the case, and the name is not registered on the business names register, if that's true, and the proceeding is started in the name under which the person carries on the business. So in other words, you're using the name Dodgy Associates. And it says there, the originating process may be served by leaving a copy at the person's place of business with the person who appears to have control or management of the business at the place. So that's how you'd serve them. So you would use their Dodgy Associates name, and you serve whoever happens to be in control of it, of that business at its place of business. And that's how you would start the process. Okay, so that's that. That's essentially what that question was all about. All right, so the key takeaways. Firstly, check the jurisdiction, which court you're suing in. Make sure it fits within that. Or it could be a tribunal if it's a lower amount. Check that. Then you have to be careful about the names or what sort of entities you're dealing with, whether they're natural persons, whether they're corporations, whether they're business names, whether they're partnerships. If they're business names, are they registered or unregistered? You need to ascertain all of that and then make sure you get those names correct in your originating process. Very critical. So that's the first set of little factors you need to bear in mind. Then you've got to think about, well, what's the nature of the claim? In this case, it's a claim. So you would all have thought breach of contract. And the reason why you thought that, which is correct, is you've been trained to think that, which is fine. But in pleadings, they have very old traditional names for things. So a claim for goods sold and delivered, or damages for goods sold and delivered, goes back hundreds of years. So when you look up old precedent, the main book is Bullen and Leak, Principles of Pleadings, I think it's called. and it sets out hundreds of these types of wordings. And there's modern variations, modern books with all of that in it as well. But anyway, this would be a claim for goods, damages for goods sold and delivered. Then you have to plead the actual elements of the contract. In this case, that there was an offer, that there was an acceptance and a breach. Okay, so a little bit more facts about the offer, when it was made, what it relates to, what the goods were, the acceptance, how it was made, whether it was oral or in writing, and then the breach. In this case, they weren't paid, so that's the breach. And then the amount that they're claiming is the amount owing under the contract, plus there would be interest as well. But we won't complicate it too much at this point with the interest calculations, but just be aware that there will be interest. And then a little bit later in the unit, you'll see how that's all calculated. Okay, so that's that one.
Can I ask a question there, Stephen?
Sure.
Before we move off this one, is that list, is that Bull & Leak the only place you'd find that list of?
No, there's lots of. I was looking at some of them. There's a more modern one here. This one is put out by Thomson Reuters. You can see a little book there.
Oh, yeah.
So when you actually open up these pleading precedents books, essentially, if I can just put that up there, it just shows you all different sorts of claims and it gives you the wordings so that it helps you frame. So there's hundreds of them in here. So that's a more modern one.
I've seen something similar at work. I'll drag it out. And the other question was, I mean, there's probably no excuse to get that wording wrong if you've got that precedent resource. But if you didn't have that precedent resource,
well, these are only guides. So that as long as you've pleaded the elements of the cause of action, you'll still be okay. These things are all designed these things are just designed to help you speed up the process. That's all.
Yeah, the exact wording isn't going to make or break.
No, as long as you plead the elements of the cause of action. If you don't plead an element of the cause of action, then you've got a problem.
Yeah.
Because you don't, yeah. So, I mean, this here, just this little section here, there's a whole chapter on claims in contract for all different sorts of contracts. So anyway, that's just a quicker way of doing it rather than reinventing the wheel all the time. Okay, we'll move on. So the next one, here we go for time. Yeah, we'll have to keep going. All right, problem 7. 4 years ago in September, Peter was injured in a water skiing accident on the Logan River just north of Brisbane in Queensland. Okay, so in terms of jurisdiction, it's happened in Queensland where he's injured. It's going to be a personal injuries claim, limitation period. What? 3 years, isn't it? You know that. Peter lost control of his ski when the tow rope snapped. Peter suffered injuries when he fell and hit his head on a submerged log. He's got moderate brain damage, incontinence, so he's in a bad way. Peter was 17 years of age when the accident happened and never skied before. Okay. And then there's all this commentary that he'd been encouraged to do this by, go skiing by this ad in the local paper. There's a company that runs this skiing enterprise. Sam Skipper's the owner of this company, and he assured Peter that it was safe and he only needed 5 minutes of training. He was a naturally perfectly safe. That didn't go too well. Peter's guardian. So, okay, so that's, we'd expect somebody is Peter's guardian because he's a minor. He's under 17. There's the other thing is you'd think about automatically because he's a minor, potential extensions and limitation periods. These things should click into your mind whenever you see these sorts of facts. So Peter's guardian, Samantha, told Sam Skipper that he was negligent in not checking the wear on the tow rope and failing to keep a lookout for submerged logs. Fair enough. Okay, that's neither here nor there. That's her opinion. And then we're asked to do various things. Assume that Sam Skipper lives in a very famous place of Snowtown in South Australia. Not famous for water skiing accidents, but their bank is very popular for dead bodies, if you remember. Anyway, so he lives there. So he's in South Australia. So you're looking at interstate service straight away if you're going to serve him. And that a statement of claim seeking damages for the tort of negligence has been filed by Peter's guardian in the Supreme Court of Queensland. The time limit for a notice of intention to defend is 28 days. Okay, so that's the standard time frame. Then you're asked, can the claim be served on Sam Skipper? Well, what do you think? Can the claim be served on Sam Skipper?
It would have to be served on the company, wouldn't it? If
It depends. It depends. Let's just think about whether it's possible to serve him first. How would you do it if you were going to do it? He's in South Australia, so how would you do that? What do you
You have to rely on the Execution and Service Process Act to serve him interstate.
Yes, the Service and Execution of Process Act, that's right. So that's what you'd use. So the objective of that act is to enable you to serve somebody interstate. And that act will apply to QCAT, the tribunal, as well as to the courts. Okay, so it's an enabling act. It enables things to happen. All right, so that's if we were suing him personally. Okay. Now, what about the corporation? If we were suing the corporation, how would we do that? And what act would we rely on? And what sort of service would it be?
Well, we rely on the Corporations Act, section 109.
109X.
X, yeah. Okay.
You don't forget the X. There's lots of provisions in 109.
Forgot for a moment it was in civil procedure.
Yeah.
And we serve it on one of the directors.
Yes, that's right. You can do that. And you can use that as an alternative to the Service and Execution of Process Act, because the corporations law, or in this case, the Act, it actually covers all of Australia. So you're not having to rely on the Service and Execution of Process Act, which was designed to overcome the problems of states, different states, because corporations law is federal. It's across all the states. So you don't need to rely on the Service and Execution of Process Act in relation to the corporation. Okay. All right. Now, if, okay, let's keep going. If Sam Skipper just receives the claim and no other documents, can he challenge the process? So if he only gets the claim, can he challenge the process, or is there an extra thing that's needed if we're suing him personally?
Yes, he can challenge the process because he hasn't had a statement of claim attached to his claim. So it's open to him to challenge the irregularity of the service.
That's even more basic than that. It's even more basic than that. Any suggestions?
I thought it would be.
What is that? You actually have to attach the Service and Execution of Process Act Form 1 to the claim. If you don't have that, that's enough to invalidate the service. Lots of twists, isn't it? So, yeah. So,
I thought it would either have been more simple
I
or more
thought that was
complicated.
good. I pay that. I thought that was a good valiant attempt, but it's more basic. It's just that. Okay. You'll get that.
Could you make it look more difficult?
But this is really basic stuff. We haven't got to the really hard stuff yet. This is the really
overthinking it. Yeah, overthinking it sometimes is your biggest.
Yes, you're right. Look, what I find, and I might have said this, I must have taught thousands of students this unit over the years. And it really doesn't start to click until week 5, I reckon, for most students. You've got to get used to the technicality of it because it's very fastidious. There's lots of provisions and you've got to be very careful. But luckily, most problems you can fix, but it costs money to fix them. You want to avoid making them in the first place. So you've got to get used to the rules and the flow charts of things, how they work, because they all work. This stuff is hundreds of years old. These are all tried and true processes. So you get used to the pattern. So if you're worried about this is all too hard at the moment, it actually will click with you and it won't be that bad, I promise. I can give you a guarantee on that because I've been doing this a long time. Okay. All right. So, so that form is needed.
You still need to put the Form 1 with it if you're not using the Service and Execution Act, you're using the...
No. If you're not using, say you were suing the corporation, well, you wouldn't put Service and Execution of Process Act Form 1 because it's relevant, because your service is based on the corporation's law. If you were suing somebody in Queensland, it's within the state, so you don't need the Service and Execution of Process Act. That Service and Execution of Process Act attachment of that Form 1 only is needed when you're suing somebody in a different state or territory. Does that help? Does it make it clear? And the relevant section of the Service and Execution of Process Act that tells you that is section 16. That's the one that says that if you don't have that form and you're trying to serve your claim in a state, that the service is ineffective. The other aspect of it under the Service and Execution of Process Act regulations, there's a rule there, 22(2)B says the claim must be accompanied by the statement of claim, which was your point. So that's right, but it was only part of the picture. So you have to have the statement of claim as well for the service to be valid. So statement of claim, the Form 1 and the claim itself are the things that would be required for the interstate service to be valid if you were serving the person, Sam Skipper. All right, okay, so then you're asked, Sam Skipper wants the proceedings to be conducted in Adelaide. Why? Because that's where he is. Snowtown's closer to Adelaide than it is to Brisbane. All right. How can he achieve this outcome? What are his chances of success? So this is back to that nasty area of cross-vesting again. Okay, so let's work our way through that again. So I had a few inquiries during the course of the week with people having problems with cross-vesting. And so we'll go through it again. So, in essence, what would have to happen is that if you've commenced the proceedings in Queensland, you would essentially, Sam Skipper would be seeking to have the Supreme Court of Queensland to transfer the proceedings to the Supreme Court of South Australia. Now, on the facts so far, there's you can't transfer it until the proceedings in Queensland have actually commenced. So we're not even sure. Assuming that they have commenced, then you'd apply to the Supreme Court of Queensland, or Sam Skipper would, to transfer it to the Supreme Court of South Australia under Section 5 of the Service and Execution of Process Act. The other thing to note is that there's no proceeding happening in South Australia that we know about. So where you end up with is looking at Section 5, Transfer of Proceedings, subsection 2B2, 2B Roman 2. So it says having, excuse me, oh, it's easier for me to just show you, I'm running out of voice, share screen. So there it is there. I'll make it a bit bigger. Okay, so there it is. Having regard to whether in the opinion of the first court, so that's the Supreme Court of Queensland, apart from this Act and any law of the Commonwealth, or another state relating to cross-vesting of jurisdiction, the relevant proceeding or a substantial part of the relevant proceeding would have been incapable of being instituted in the first court and capable of being instituted in the Supreme Court of another state of territory. Well, it's not incapable of being commenced in the first court, because it is capable of being commenced in Queensland because the accident happened in Queensland. That's where the tort was committed, and that's also where the plaintiff is. So that didn't really take us that far. So having regard to that, so that's favouring Queensland more than South. The only thing that's in South Australia is one of the potential defendants. B, the extent to which, in the opinion of the first court, the Supreme Court of Queensland, the matters for determination of the relevant proceeding and matters arising under or involving questions as to the application, interpretation or validity of a law of the state or territory referred to in subparagraph A. So the state or territory, it's more in favour of Queensland than the law of South Australia. And then it comes down to the interests of justice. Is it more appropriate that relevant proceedings be determined by the other Supreme Court? Well, the interests of justice, what are the factors that favour that it should be heard in Queensland in terms of the interests of justice? What are the factors?
Probably the defendant's injuries. And
The plaintiff's injury.
Yeah, the
sorry,
plaintiff.
plaintiffs, yeah, sorry.
So the plaintiff is in Queensland. The tort occurred in Queensland. That's where he was injured. Presumably, and you'd have to inquire more. There'll be various doctors and people giving evidence. Most of those are going to be likely based in Queensland. What's the other way in favour of South Australia? The only thing about South Australia is that one of the potential defendants is there. And that's about it. So in terms of the interests of justice, it's more likely to favour Queensland. So I think that's your answer, basically looking at this. So that transfer is unlikely to be successful. So there's a case there that you can look at. There's also cases mentioned in the case book, and it gives you examples because there's not a defined list of circumstances. It depends on the case. There may be other sorts of factors that become relevant. For example, it might relate to the age of one of the defendants. Say Sam Skipper was 95 and can't travel anywhere. That might be a factor that says it might be in the interest of justice that everybody travel to where that person is. So it depends on a whole host of factors. It's one of those, it's a discretion, basically. So
what if Sam Skipper was completely impecunious, totally broke?
Oh, Sam Skipper, well, in that case, if Sam Skipper is totally broke, one of the first things you would have worked out is whether they were worth suing or not.
Yeah.
If they're totally broke, you wouldn't bother. Same with the corporation. It may well be, one of the things you would naturally look into, given that this whole action is going to cost hundreds of thousands of dollars to run, you need to make sure that the person or entity you're suing is actually worth suing. And the other thing that happens too, they may initially look to be worth suing and they start transferring assets and hiding them. So there's all sorts of rules about preventing them doing that as well. Because people get up to all sorts of mischief when they get sued. Suddenly their assets disappear, they start selling things, liquidating them, turning them into cash, which then disappears. So there's a whole lot of stuff we'll look at later on about that. But that's certainly a big question to ask initially, are they worth suing? Because if they're not, none of this should even be entertained or thought about beyond the first half hour you're talking to the client. That's a good point. I should have mentioned that last week, actually. Okay, now, so we've got another one there, this bit here. Assume that shortly after the accident, Sam Skipper sold the business and moved to California. Okay, so if they're in California, there's a few things that come out of that. You get a longer time period for service. So when you're looking at the rules, remember it was 28 days before, now it extends to 60 days. The Service and Execution of Process Act is totally irrelevant because that's only enabling service within Australia. It's not enabling service to the United States. So you're going to then have to look at either two alternatives. One is the rules related to service outside of the jurisdiction. So you can have a look at Rule 124. And that's a really complicated rule, only in the sense that it gives you lots of factors of what they call nexus or connection. So when you look through the factors in Rule 124, the factors that connected to the jurisdictions, the tort occurred within the jurisdiction and the damages occurred within the jurisdiction. And if that's the case, leave's not required to serve them overseas. The other way it can go is under the convention, the Hague Convention. So there's an international convention for inter-country service known as the Hague Convention. Not all countries are signatories to it, but the US is one, Australia is another. So it does enable you to serve under that convention. So there's special rules around that. So that was that. I think it was really asking you whether Form 5 of the Service and Execution of Process Act was relevant, and it isn't. That's only domestic, not international. All right, then you're told Peter knows that Sam is now living in England and that Sam's gone to extraordinary lengths to evade service and cannot be located. What can Peter do and what are his prospects of success? Other examples of this is where somebody's keeping house. It's an old bankruptcy term where somebody actually boards themselves into their house and nails all the doors and windows shut. And you can't serve them because they're locked up in their building. The modern equivalent of that is when somebody's in a multi-story building with a lift that you have to press the button to get access to and they never let you get access. That's a form of keeping house. Same problem, it prevents you serving them. So what do you do in that situation? What do you do if you're having trouble serving them and it requires personal service? Remember, personal service is required for the claim and the statement of claim.
Substitute service.
Yes, so then you're looking at substituted service. Okay, now a couple of little tricks with substituted service is that firstly, what's the relevance of your attempts to try and contact them and get them to pay prior to you filing the claim? Is that relevant to substituted service? Because what's substituted service actually trying to achieve?
Trying to get their attention and their awareness.
But to do what?
Awareness of the process.
You're trying to serve them with the process. So in other words, you're trying to serve them with the claim and the statement of claim. Now, if the claim and the statement of claim haven't been filed, so you haven't actually started the proceeding, but you've been trying to contact them to get them to pay out, is that relevant to a substituted service application? It's a question of timing. What do you think? Everybody's gone silent. But technically, if you think about it, technically substituted service, you have to show that you've made attempts at service. Service means service of the claim and the statement of claim. If that doesn't exist yet, then, you know, evidence that you've tried to contact them unsuccessfully is not that relevant. What would be relevant is your attempts at service of the physical documents that have been created and filed, and you can't actually serve them. And then you've got to prove two things for substituted service. So what have you got to prove? Remember, you're making an application to the court for an order for substituted service. They don't give it to you automatically. You actually have to argue the toss. It's an interlocutory application.
You have to prove that you've made reasonable attempts to serve them already.
That's right. And not just that, there's a bit more to, you're nearly right. The bit you've left out is that it was unsuccessful.
Yes.
Okay, so you've made reasonable attempts. So or you document all the attempts that you've made. Okay, how does it work in a COVID world? Not very well. Not very well at all. You know, it's convenient if they've got a solicitor appointed. It's very easy to serve people. They can do it electronically. But what you would do is you'd still have to say that you've made attempts. So you would say you've tried to contact them electronically by telephone. You have visited, presumably if you can, at that time, subject to whatever the lockdowns or whatever we have. You might have engaged a private investigator to try and serve them, and you document all the various attempts that you've made to try and bring it to their attention, but it still hasn't worked. That's the first element. What's the second element? Okay, so you've established that you're having tremendous trouble serving these people, but what else have you got to convince the judge? That the method that you're proposing is likely to bring the proceedings to the defendant's attention. Because remember, it's in order for substitute of service, you've got to say what the substitute is. So you can have all sorts of different methods. It could be post, it could be advertising. If it's a ship with a mast, you can nail it to the mast. You can do all sorts of things.
Keyword there being likely.
Sorry, what was that, Lindsay? Just say that again.
Keyword there being likely. It's not a guarantee if it's substituted service. It's not a guarantee that
you're not giving a guarantee. You're not giving a guarantee. You're proposing the method, and the judge is making the decision as to whether they think that that method's appropriate.
Exactly.
Like if you can establish contact with a relative of the person.
Absolutely. Yep. So that
you believe that that relative may bring it to their attention because
how do you prove that? So how would you prove that? Remember, you've got to prove this to the judge that this is a viable method.
Just with the subject of serving on a third party, be it a relative or a friend, how do you know that they're not estranged? You need to prove all of that.
That's right. So that how would you do it?
If you'd seen that they'd had contact on social media, or
now that's right.
So
that's right. So you can put in, remember, interlocutory applications are not subject to the hearsay rule. So you can be informed by someone. So you may have sent a process server around there, and the process server's knocked on the door and keeps a record of the conversation. Do you know X, Y, Z? And the person says yes. Are they around? No, they're going to be back tomorrow. That then goes in the affidavit. Okay, so here we have somebody who says they know them and that they're going to be in contact with them tomorrow or at some stage. That's an example of evidence. If you can find it on social media that there's regular posts that on Facebook or whatever that shows these people in regular contact, there's more evidence. Anything that you can use to prove that there's this connection, and that the connection between the person you're trying to be served and another person, then that's going to assist your argument that this other person can be served as a method of bringing the actual claim to the attention of the person you're suing. So,
failing all of those attempts, so in particular, if you're dealing with somebody who's overseas and who's purposefully evading service, then you just have to prove reasonableness. This is the most likely way, but you can't guarantee that it's going to succeed, but it's the most likely. And if that doesn't work, then you've still satisfied your obligation.
That's right.
To at least try.
That's exactly right. So what happens is that the court, in making the order, specifies the steps to be taken, and the rule 116 then basically says that if you follow those steps, then the document is taken to have been served on the happening of the specified event or at the end of a specified time. So they'll then be assumed to be served, and then the proceedings will go along, and if they don't react in any way, you'll end up with a default judgment situation, which is a quick, convenient solution, and then you would start execution against their assets then, which will be another challenge. If they're evading service, they'll probably be hiding their assets.
Yeah, that's what I was heading at with. If their assets are locatable, then, as you said, nailing the notice to the mast is probably a pretty good method of service, because if it's a company or something with a physical building, it's like services delivery to the office. But, you know, if they have any kind of asset that you can locate, then sooner or later you're going to locate the person, aren't you?
That's right. And by the way, nailing to the mast isn't a joke. That's what they did in the Admiralty jurisdiction. It's actually what they did. They nailed it to the mast of a a sailing ship. So yeah, there's lots of ways of doing it. But you understand the basic process is set out in Rule 116, and it's just a question of collecting the evidence and making the attempts, and then coming up with a viable means that you can convince the judge to make the order. So that whole order is going to cost you about $5,000 by the time you pay your barrister and everybody else. That little interlocutory application. So it's not inexpensive, these processes. All right. All right, fine. Okay, the last one. Problem 8. Stuart Orangeby has contacted your firm and provided you with the following summary of events in relation to his son, which basically the problem is full of dates and times. And so immediately you've got to take notice and produce a timeline and work out expiry of limitation periods and extensions and all of those sorts of all of those situations. But basically what you've got is a young person who gets injured in a car park of a local supermarket, and he wants to recover against the owner of the shopping centre and one of the shops there, and he suffered all these injuries, and it's effectively prevented him from potentially having a career as a rugby league sportsman type person. Okay, so if we just go through it, given the time, I might just run through it. So he was born on the 18th of the 11th, 95. Injury was on the 21st of the 4th, 95. So he would, so he's going to be, I think, 9 years old at the time of the injury. And then the claim's brought sometime after that. So he's going to get an extension of time until, well into the future. So that issue, we'll just put that aside for the moment. We'll just assume that he's within time. So then he's got to initiate the claim. And it's all those things we talked about earlier. It's got to be in the right form, and it's got to have the statement of claim attached. And so it's in Form 2, and also that's the claim, and Form 16 for the statement of claim. So this is the claim for personal injuries. Now, the thing about this is, given that it's personal injuries, it's going to be hard to calculate the amount of damages. Now, in Queensland, unlike a lot of other jurisdictions, you've actually got to have you've got to put forward in your statement of claim estimates of what the amounts will be. So if we look at all of the amounts, all of those filing fees apply, except we're dealing with a person, not a corporation, as the plaintiff. So that's how I've calculated all these figures, which you'll be able to look up. With the actual claim in tort, you've got various pieces of legislation which could be relevant. So there's the Civil Liability Act. Now, 2003, no doubt when you did torts, you would have had long discussions about the Civil Liability Act. And if it was a workers' compensation claim, which it isn't, but if it was, then that Act and Rehabilitation Act associated with it, Workers' Compensation Rehabilitation Act would apply, but not on our facts. But the Civil Liability Act 2003 would apply. And the usefulness of that is it helps you with the assessment and calculation of the damages. So there's lots of provisions in the Civil Liability Act around assessment and calculation of damages. Now, I'm not expecting you to go into that. There could be a whole unit or probably several units just working out how all of that works. But I just want you to be aware that that helps you in the assessment of damages. I've given you some links to the various provisions for that, and also a link to Carter Newell lawyers. They've got a fact sheet that sets out how some of these things are calculated. If I just share the screen again, so I'll just show you what this claim looks like. So it's in the Supreme Court. Plaintiff is Peter Orangeby, and then you've got William Hustings, the owner of the shopping centre, and then you've got this particular shop as well. It's damages for personal injuries, so that's the short form type of claim. The rest of this form is pretty well in form 2. Okay, then you've got basically that they're represented by a solicitor and their details, who it's going to be served on and their addresses. And don't forget the little footer that has those details. Then you get to the statement of claim, which is the pleadings. So, all right, Stuart Orangebeard is whatever years of age and resides at that address. Video Champs. So this is explaining who the various people are. Video Champs, the owner of the video store. Hustings is the owner of the shopping centre. Okay. So remember, with a tort, you've got to set out, you know, the duty of care and all of that sort of stuff, and what basically all of the elements. So if we look at it, the plaintiff was driven there by his father, and you know, the car park was poorly lit. The plaintiff tripped, so you can start to see what the negligence was. As a result of tripping, he cuts his arm, breaks his leg, does all of these things, and there's particulars of the injury, so more details about what the particular injury was. Then the injuries were caused by the was sustained by the plaintiff, were caused by the negligence of the first defendant. Then the particulars of the negligence, of how they were negligent, failing to take reasonable care for safety, you know, not maintaining lighting, didn't maintain the concrete guttering, didn't erect warning signs, didn't remove tree roots. All of those things were the reasons why there was this negligence. So that's in relation to the first defendant, who's the owner of the shopping centre, and the same thing for the owner of the actual business. Then you're saying that because of that failure in their duty of care, then there's damage resulted in the injuries. Loss and damage has occurred and will continue to incur expenses. But this is the part I was trying to get to before. You actually have to make an estimate of it. You can't just say damages will be assessed by the judge. Ultimately, they will be, and the precise amounts worked out. But you actually have to put in your estimates of what these things might be. So general damages usually cover things as I've listed there: physical injuries, psychological injuries, pain or suffering, loss of enjoyment of life. Special damages, these are things that are usually easier to calculate. So medical expenses, he would know what his medical expenses were up to that date of this claim and make some sort of estimate as to what they were for the future. Travel expenses to and from hospital, that sort of stuff. Costs of medication, loss of future wages. These are the big ones. Apart from the physical injuries, but the loss of future wages might be a big thing here, because this was a person who was likely, or at least they're arguing, was likely going to have a successful career, which they now won't have because of this injury. And it's not only loss of wages, but also it's the superannuation benefits that they would have obtained on those wages as well. So these are all items of special damages. Now, I've made these figures up, but the actual legislation helps you calculate these things. And there's actually books that have been compiled, which will say if you lose an eye, then it equates to this amount of money. If you break your leg, it equates to that amount of money. So there's tables and books that help you calculate these figures. Anyway, I've made those up for the purposes of showing what this looks like. And then we've got the amount of the claim, which is all these things added up, less the interest, the filing fees, which we know how to calculate because I showed you how you calculate those from the various regulations. And then what the estimated, well, the solicitor's fees are a bit cheap at that point, but anyway, that's what it is. And then you have the notices to defence. If they don't defend it, then there's the cost of entering into judgment in default, which is pretty minor, isn't it? You know, $467 in a claim that's 1.9 million. But that's basically it. What I might do is contact some of my mates and solicitors firms to do this work and see if I can get some examples of real ones rather than our made up problem here, so that you can see exactly how they're played. We'll make them anonymous so that you know, but I'll see if I can get hold of some of those. Should be able to, so that you have some real examples. But this is just basically setting out how you would approach this in dealing with these forms and the sorts of considerations that are relevant.
Stephen, is there anything implied in the order that you have assigned
No.
to the defendants?
No, doesn't matter. Doesn't matter about the order. No. So that's not an issue as long as they're made a defendant. That's the important aspect. Yeah.
Just on the issue of defense, and I may be going way off track here, but it does say in this scenario, Dad drove me home and then Mum called the ambulance. Why was the ambulance not called on site? How can you prove that those injuries?
That could go to something like mitigating loss. Maybe, I mean, we don't know, but you know, if you were the defendant and looking at that, you'd be saying, well, because of that delay, did that actually make the damages worse than they would have otherwise have been if this person had been treated earlier? Could be relevant to mitigation.
Or even did all of those injuries occur on this particular site?
Well, that's right. So that does raise questions like that. So if you were the plaintiff and you were told that, you would be asking more questions. Well, why was that the case? If your son is so badly injured, why are you carting them around the neighbourhood?
Exactly.
Taking them, either taking them directly to the hospital or more likely ring the ambulance. Well, yeah. So I didn't do that intentionally, but it does raise that issue. Yeah, fair enough. Now that's a good point. So it does raise another issue, which I need to emphasize too, is that you always should check your client's story independently if you can, because clients will lie to you. They might do that on purpose. They might do it inadvertently, in the sense they'll tell you something that they think you need to hear, and they're not telling you things that they think you shouldn't hear. Just in the same way that they will shred documents, and if they're not very good at that, they'll shred documents, but there'll be some other document that refers to the document that's been shredded, which then really attacks their credibility. Why are some documents in existence and there's these gaps in your document? Then when we get to disclosure, all these things will become relevant. So what I'm saying is, bear in mind your clients will lie. So try and verify everything from alternative sources if you can.
It's interesting. I've found in my short career so far of interviewing clients that they can be quite defensive if you ask for some form of verification of their claim.
Yeah, they are, because you're impliedly accusing them of lying. That's why.
Doesn't need confirmation. If it's there, it's there. If it's not, well,
you're dealing with personalities and people, and they react in different ways. But at the end of the day, you've got to make sure that you're asking the right questions to get the information you need to be able to make a valid assessment and give them correct legal advice. That's where ultimately that's where you want to get to. And if you can verify what they're saying by alternative means, for example, you say to them, well, if you're coming to see me, bring all the documents with you. Bring all the documents with you. Was there anybody else there at the time? You know, so you can start to see what other witnesses there may be. Was it, was any of this recorded on a videotape or whatever? You know, that you're looking to find out all of these things that help paint this picture of how accurate the information you're being presented with is. Don't accept anything on face value. It'd be nice to think that everybody who came to see you was telling you the truth, and a lot of people will, but not everybody, and it's hard to work out who's who sometimes. So you need to be careful and take it at face value and check everything. Even if they tell you, well, the name of the business was this, you need to actually look that up and make sure that that is actually correct. So you do your Australian company search, you look up the business names register, all of those things as part of your due diligence. The other thing you need to do, of course, is look up your conflicts register within your firm. Make sure you haven't acted for the other side potentially in the past, that you don't have conflicts, or that if you're in a big firm that they're in fact not running a litigation in some other section of the firm somewhere, that prevents you from actually even taking the case in the first place. So there's issues like that as well. All right, it's 7:15. I think we've probably exhausted our time for tonight. So I will post up the answers and that I've got, suggested answers, and the recordings. If you've got any other questions, feel free to email me. Probably email is the best way. And we'll go from there. Do start to get into your assignment though. Time's ticking on that, and there's lots of things to think about in that assignment. So I'd like you to start that sooner than later. All right.
Stephen, can I just ask one last thing? Are you posting all of these into Teams?
Sorry, I'm having trouble understanding. I don't know why.
I'm just asking, are you posting all of these answers and
yes, I am, and I have been. So if you actually look in Teams, in the actual questions underneath them, there's various people who've posted answers and things. You'll find these, I call them items to consider, but it's really sort of suggested answers. You'll find them in there, and the actual recording you'll find in Moodle in the week. So say this week's tutorial relates to week 3, so I'll post the YouTube video into week 3 tile. So if you go and look, so there's 2 sources to look at. The Moodle site will give you the videos, and the Teams site has the actual written text.
The Moodle site I've got down, it's just Teams I've only gotten access to this week. I've been tearing my hair out trying to get a hold of it. But okay. I've got that up.
Well, anybody who looks at the video, if you're having trouble with Teams access, just send me an email because I can automatically enroll you if you're having trouble, and that's the quickest way.
Well, good. Thank you.
It's all a bit of a learning experience, I must say, with Teams. I'm not entirely convinced it's the way to go, but anyway, we'll give it a go. All right. Okay. Well, we might stop there if there's no other questions for tonight. And I'll talk to you again. Next week. But if you have a question, email me.
Thank you very much.
All right. Have a good night.